Hello students and welcome to the next session of company law. I hope you all are doing well. So in the last session we discussed about the role of auditor in the company, how auditor gets appointed, audit various audits gets conducted. Now we are going to move on to the next topic. The topic name is director. Okay, so we are going to talk about the position of the director, the provisions relating to the appointment of the director. So the first question which will come to your mind, who is a director? Okay, and what is the collective, the name of the collective body of directors? So in order to understand that, first we need to understand two different concepts which are given under the Companies Act 2013. So the first concept which says that board of directors, board of directors. The definition of board of directors is given under section 2 subsection 10 of the Companies Act, which says that, I am going to use the short form for the convenience purpose, BOD, that is board of directors, or board in relation to the company, in relation to a company, means the collective body, the collective body of directors of the company, of directors of the company, whereas the director is defined under some other section. So the director is defined under section 2 subsection 34. As we all know, okay, definitions in the Companies Act are given in the alphabetical sequence. So director means a person, it means a director, you can say a director appointed to the board of company, the board of company. So after reading this definition, the role of director may not be very much clear, I am sure about that, but when we will talk about the corresponding provisions relating to the director, as well as, okay, there are various provisions in the Companies Act where the board or board of directors or the director reference is given. So in order to understand the exact role of director, we need to understand the provisions of the Companies Act 2013 very well. So directors, basically in nutshell we can say directors are basically the individuals who are appointed to manage the business affairs of a company. So now you will ask, okay, so the shareholders are also there, so how come only the director can manage the affairs of the company? So company being an artificial legal person, this concept we had talked from time to time, it is a separate legal entity in the eyes of law. So it is having that separate legal existence which is created by the law without a physical body or the mind of its own. And that is the reason it needs to be managed through human beings. And who are those human beings? Those are the directors. So though the shareholders, see, there can be human beings who are the shareholders of the company. So though the shareholders being the owners may be physically available to manage the affairs, but their number may be large. Because when we talk about the giant companies like Reliance or Tata's, Infosys, we have n number of shareholders, so their number can be large and we cannot ask them to run the managed affairs of the company, because okay, if it is done so, okay, then it may be mismanaged and nothing else will be achieved. And that is the reason the concept of director has emerged over a period of time. So directors may be elected from among the shareholders or from the outsiders. So they need not be the shareholders of the company. They can be elected from the outsiders as well. Okay. So we need to understand the exact legal position of the director. Legal. So before proceeding further with the provisions, we need to understand legal position of director. So we can say that, okay, legal position in two different categories we can understand. Directors are the agents of the company, or directors can be, okay, can be considered as the trustees of the company. So they may play a dual role. So they can be considered both as agents as well as directors can be considered as trustee. Okay, so as agents, they bind the company as their principal as soon as they enter into various transactions on its behalf. So if directors are authorized, okay, to do certain act on behalf of the company, and if they are entering into certain transaction, so they are going to bind a company through their acts. And that is the reason the directors are considered as agents of the company, because the law of agency comes into play and it governs the relationship between the company and its directors. So it is the law, okay, the contract of agency, you can say, it is created by the operation of law itself. There did not be any kind of separate, you can say, agreement to that effect to create this particular, okay, type of relationship. So companies act, so they may be at times, you can say, principal as well as agents in respect of certain acts, because their acts may not be delegated further. Certain acts may not be delegated. So Companies Act 2013 has laid down the provisions requiring as to when the company needs to act them as principal as well as agents. And when the directors need to act as the agent, it may be noted that where directors are empowered to take certain decisions. The company cannot negate them or issue directions to the directors, directing them. So, company, there are certain provisions where directors can directly take the decision. So, even the shareholders may not have the full control over it. Okay, only the control which can be there, okay, which can be exercised by the shareholders, that they can remove the director or they can appoint a new director in the place of the retiring or the removal of, in case of removal of director. So that is the only check, okay, available with the shareholders of the company. So this is the role of the trustee, agent. Okay, so they are the agents of the company and they play various roles and they represent the company. Okay, so we can say as directors represent company. As directors represent company. So when we talk about the role of the trustee, okay, how can we say that? What is the main objective, or you can say the role which is played by the trustee is a kind of fiduciary role. Okay, he is a kind of caretaker for a company. Okay, because the management of the affairs of the business of the company should be, okay, conducted in the manner as provided under the Companies Act, rules made under articles of association and memorandum. And that is the reason he is a kind of caretaker, he is a kind of trustee for the company form of business. So when we say the directors are trustees, directors are required to take care of the properties, money, okay, again the trade secrets of the or business secrets of the company belonging to the company. In fact, as a trustee, director are in the fiduciary relations. Okay, so we can add this particular point. Directors are in fiduciary रिलेशंस. ओके, तो उनका रिलेशंस कैसे है? डायरेक्टर्स का फिड्यूशियरी रिलेशंस है. Okay, and once with the company, and if such relationship is broken, the company may suffer loss, okay, because of the illegal acts of the director. And that is the reason, okay, director plays a vital role, okay, in the affairs of the company. So there is a definition of officer which is given under section 2 subsection 59 of the act, which says that officer includes director, which means a director at certain times is also the officer of the company. Okay, so when we say officer in default, so director may be, okay, may be held liable for some kind of default which he may commit in the name of the company. So he may play a dual role again of a director, employee, various roles he can play during his tenure. Collective body of the directors. So it is called as board of directors. It is the board which takes decision at its meeting. So collective body of the directors is called as board of directors, which may take the decisions at its various meetings. So the quorum requirement is prescribed and the collective decisions are taken. But there are certain provisions in the company law, we will talk about that, okay, how the board meetings are conducted. There are certain provisions where the board meetings are not required, even the resolutions can be passed by circulation. Now we are going to move on to the provisions of the directors. So the first provision we are going to talk about section 149, which says that company to have board of directors. Company to have board of directors. Okay, section 149. So it contains provisions which require, so this particular provision says that every company to have a duly constituted board of directors. So we say that every company shall have BOD consisting of individuals as directors. So what does it say? Every company shall have a BOD consisting of individuals as directors. Consisting of individuals as director. Okay, so when we say that consisting of individuals as director, so any body corporate or the partnership firm or association or person may not become directors. Only individuals are allowed to become directors, because as I said earlier, okay, the decisions can be taken by a company being the separate legal entity in the eyes of law. It may not be managed, okay, by the day-to-day operations of the company may not be managed by the body corporates, and that is the reason individuals will be required to manage the affairs of the company. So only individuals can become the board of directors of the company. So every company shall have, okay, every company shall have. So what is the minimum requirement and the maximum requirement? We will try to understand. So when we say will use a different color, minimum and maximum. Okay, so when we say minimum, now there are again three criterias and a maximum. Okay, so minimum, when we talk about the minimum, so we need to understand that, okay, there can be three different types of entities. First one is public limited, second one is private limited, and the third one is OPC, public, private, OPC. So in case of public limited, it is 3, In case of private limited it is 2, and in case of OPC it is 1, only 1. And maximum requirement is 15. Okay, so this is the limit which is given, okay, under section 149. So if the company wants to appoint more than 15 directors, it can do so by passing the special resolution. Okay, so in case of more than, okay, company wants to have the more than 15 directors on its board, the company will have to pass a special resolution. So I think add this particular point. If company wants to have more than special resolution, okay, the special resolution will be required. So you should not forget the minimum and the maximum limit which is prescribed over here. Now we'll talk about certain different aspects of it. So one of the aspect is woman director. So as we have already seen, okay, company should have the minimum and maximum. Then company should have at least one. So I can just make a pointer over here. A company should have at least one woman, at least one woman director. For specified companies, not for all, for specified companies. So which are those specified companies? Like we can say listed entities, listed companies, where you will require women directors. You may have every public company having paid up share capital more than 100 CR or more, turnover more than or equal to, you can say, 1000 CR. Sorry, not 1000, it should be 300 CR, 300 CR or more. Okay, so these are the limits given, okay, in the new Companies Act. This particular, okay, limit was not there earlier. Such kind of particular provision was not there. So one woman director has to be appointed. So if these are the conditions, okay, have been made. So company, so for the purpose of having a woman director, it is clarified that the paid up share capital or turnover as on the date of latest audited balance financial statement shall be taken into consideration while appointing the woman director. So after that there has to be a resident director. Every company should have the resident director. What is meant by resident director? At least one director who stays in India, for minimum 182 days during financial year. So now companies will have to ensure that, okay, out of their board of directors, at least one director should stay in India. Then company should have independent director. Prescribe companies to have independent directors. In short, we can call them as IDs, that is independent director. This provision we will talk in detail a little later. So now the classification of the directors. Who is an independent director? Basically the prescribed companies like large companies, public limited companies, this condition is mandatory because it will give a boost to the level of the corporate governance, because these are the neutral persons, they have to maintain their independence while taking the decisions, because they must be managed, the public money must be managed, which should be invested properly in the best possible manner, and we will check that independent director. So he should have that independent mindset, which should not be unduly influenced by the other board members, and that is the reason this provision of the independent director has been incorporated in the Companies Act 2013. Earlier this provision was there in the Israel company form of business into the listing agreement, and we used to follow that. Now the classification of director, the other way of classification of director can be executive and non-executive directors. Directors can be classified as, you can say, in the two categories, executive and non-executive. So who are the executive and non-executive? Okay, so executive directors are basically responsible for managing the business operation undertaken by the company. So it is the responsibility of these executive directors that the departments which they head should operate smoothly. So they you can say that EDs are responsible for managing operations of company. So who can fall under this particular category? Like MD may fall, managing director, full-time directors may fall under this category. Okay, whereas non-executive director can be classified into two categories again. Okay, so they can be either non-independent or independent. Okay, so independent directors always they fall under the category of non-executive directors. So these directors participate through board meetings. Okay, they in the discussion or various audit committee or various committee meetings for framing the policies of the company, for the effective management of the company. So always remember, independent directors are always the non-executive directors, and they are not the active, they do not take the active part like the executive directors of the company, and they can only be held liable, okay, for the act of the company if they have knowingly consented to the wrongful acts. So you can say independent They participate through board committee meetings. They participate through board committee meetings. So here we have completed section 149. So let's quickly go through it, whatever we have completed so far. So we started with board of directors. If you want to make a note of this, please make a note of all these points. Board of directors, then directors definition. We talk about the legal position of a director is like the agent and the trustee, as directors represent the company and they are in the fiduciary relations. Company to have the board of directors. Women director, resident director, then independent directors. We talk about the classification of directors. So executive, non-executive. Executives are responsible for managing the business operations of company. Non-executive can further be classified into non-independent and independent directors. They only participate through board meeting and audit committee meetings. Now here we will talk about appointment of directors. Appointment of directors. Appointment of directors. First directors. Okay, so appointment of first directors. So in absence of, we can say in absence of any provisions in AOA, the subscribers to MOA, because individual, okay, shall be deemed to be first directors. Okay, so in absence of any particular provision in the AOA, okay, in case of you can say OPC, that is one person company, and individual member shall be deemed to be first director. Okay, so when the question arises who will work as a first director, so provision is very clear that in absence of any provision in the articles of the company, the subscribers to the memorandum till that time, okay, will be considered as first directors, and in case of OPC, that is one person company, the individual members will be considered as the first director. Now what about the subsequent directors? So when we say we talk about the subsequent directors, so that is something different than the first directors. So we can say that every director shall be appointed by the company in general meeting. Appointed by the company in general meeting. Okay, so director can be appointed in general meeting. So when we say general meeting, it is the shareholders meeting. So shareholders of the company will decide who will be the director of the company. Now there is one exception. There are various exceptions, like if the shareholder is not there, if the requirement is there in between the general meeting, then additional directors, alternate directors, or casual vacancy can be filled up by the board of directors of the company. Okay, so you can say exception additional alternate directors can be appointed by BOD. Can be appointed by BOD. Okay, so these are some of the important requirements, but other requirements are also there with respect to the appointment of directors. Let's try to find out other requirements of appointment of the director. Of appointment of director. So first requirement is allotment of director identification number, which is also called as DIN. Okay, so the director, okay, I'll just explain this point. I'll first write down all the points. To act as director, explanatory statement, of ID. Okay, these can be some of the important points. So allotment of DIN is a compulsory number for a proposed director who is to be appointed. He has to obtain the DIN first, okay, that is director identification number. He has to file the forms for that. He has to obtain that. After that, okay, wherever he is going to be a director in any company, he has to provide that particular DIN number. Along with that, he has to furnish a declaration that he is not disqualified to become a director. So there is a criteria for the disqualification. So he is not disqualified from becoming a director in the company. He has to provide that declaration in the prescribed format. Written consent. So written consent, see, you cannot force anyone to become a director. So for that is a reason, okay, the director who is to be appointed has to give the written consent that he is ready to become a director in that particular company. So he has to provide that written consent. It should be furnished in form number DR2. Okay, the company shall file the consent of the director with then ROC within 30 days in DR12. DR12 is the appointment form of the director. Explanatory statement to be provided when the independent director is to be appointed during the general meeting. So explanatory statement will provide in the opinion of the board that he fulfills all the criteria for this for the appointment of the you can say independent director. So these are the some of the important again provisions relating to the directors. Then there can be one more provision, that is retirement of director by rotation. Retirement of directors by rotation. Okay, so this is provided that, okay, if directors, okay, it deals with directors by rotation. So why there is the provision relating to the retirement by rotation? Because incorporation of such provision at no stage, okay, try to understand, at no stage the self-perpetuating management should take control of the company. So it should not happen that directors will take the control over the company, and that is the reason this retirement of by rotation provision has been given. The board of directors is allowed to control its own composition in such a case if there is no such provision. In absence of this provision, so that in absence of such provisions, okay, the directors can start dictating the terms like how long a director can serve, and even it can elect or re-elect director itself, and that should not happen. It will be really harmful, okay, for managing the affairs of the company. And that is the reason the shareholders are the owners of the company, and the concept of rotational director has emerged. So it will enable them not to re-elect a retiring director. So shareholders can decide that they do not want to re-elect the retiring director, okay, if there is unfavorable opinion about them. So to whom, unless otherwise provided in the articles, not less than two-third of the, just a moment, so it is given that unless the articles provide for the retirement of directors at every annual general meeting, not less than two-thirds of total number of directors of the public company be persons whose period of office is liable to be determined by retirement of directors by the rotation, and save as otherwise expressly provided, be appointed by the company in the general meeting. So basically, okay, one-third of such directors for the time being, okay, at the first annual general meeting held next after the date of general meeting at which first directors are appointed, at every subsequent AGM, one-third of such directors for the time being as are liable to retire by rotation. or if their number is neither 3 nor a multiple of 3, then the number nearest to one third shall retire from the office. So these are some of the provisions where given in the Companies Act. So one third directors one third directors retire every year. One third directors retire every year. And directors liable to retire two-third. Directors liable to retire are two-third. Okay. So I can give you example. Let's assume that there are 6 directors, then the two-third number will come to 4, and out of 4, okay, one third, that is one director should be retired, okay, by rotation every year. So whether they can be reappointed, yes. So where there is a vacancy created, the retiring director can be reappointed, okay, during the AGM by the shareholders of the company. So there is no harm, okay, in the reappointment of the director. So now we'll talk about the further provisions relating to the DIN, Director Identification Number. Okay, so here it is given section 153 deals with the filing of application for DIN. So every individual intending to be appointed as a director shall make an application for the DIN in the prescribed form. So every person to be appointed as director should make an application in prescribed form. I should directly write down the form number in DIR3 form. Okay, so in DIR3 form the application has to be made. Okay, then after that, now it is provided that a proposed director is not having approved DIN at the time of incorporation of a company, this can be now, okay, applied. Then along with that, which documents are required? So there are some documents which are required. So this provision is basically given under section 153. Okay, so documents which are required, so you can say photograph, then proof of identity, proof of resident, then board resolution, DSC, that is digital signature certificate, is also required. After that, okay, the government will allot the DIN. Okay, so as per section, according to section 154, the central government shall allot a director identification number within 1 month from the receipt of allotment of DIN as per section 154. So you can say it is done by CG within 1 month from application. Okay, from the application date within 1 month the DIN can be given. So if CG finds that application is defective, okay, then it shall give intimation for the defect whatever here CG has identified by placing the details. CG may reject the application and so on. So after that, okay, director will have to intimate the DIN to the company. Okay, director will have to intimate the DIN to the company that he has obtained the DIN, and that intimation has to be given to the company. So we'll write down the few pointers over here. Okay, so next पेज पे हम लोग लिखेंगे prohibition on obtaining more than one DIN. Okay, so prohibition is obtaining for one DIN is given under 155. So who has already been allotted one DIN, okay, shall apply for obtain or possess another DIN. So nobody can do that. Okay, no person can do that. Then directors to intimate DIN section 156. Every existing director within 1 month of the receipt of DIN, okay, should intimate DIN to the company or all of the companies where he is a director. Then company to inform DIN to registrar. After that, company to inform DIN to ROC. That is given under section 157. So every company shall within 15 days from the receipt of intimation under section 156 furnish the DIN of all its directors to the ROC or any other officer or authority as may be specified by CG. And then the punishment part can be there. So very quickly we are trying to understand all these provisions. If company fails to furnish DIN to ROC, the penalty, what can be the penalty for it? Let's try to understand. So there can be two penalties. On company and we can say defaulting officer. Okay, so on company and defaulting officer, then fine of rupees 25,000 to 1 lakh, and for every defaulting officer, okay, 25,000 to 1 lakh. So there can be again penalty of 100 each day, okay, will be levied. So this is 157. 158 says that obligation to indicate DIN. Okay, so obligation to indicate DIN provisions are given under section 158, which says that every person or company while furnishing any written information or particulars as are required, okay, shall maintain DIN in such written. On every written, okay, on every written information or particulars as to be furnished as per Companies Act 2013. Okay, the DIN number has to be specified. So punishment for contravention, if any individual or director makes any default in complying with the provisions, then there can be penalty of 50,000, that is given under section 159. Okay, punishment for contravention of 152, 155 and 156. So punishment for contravention to 155 and 156. Any individual or director what will be the penalty? Okay, up to rupees 50,000, okay, and 500 rupees per day default. So these are some of the provisions. Okay, so these are some of the provisions given till 159. Okay, so this provision is given under you can say section 159. Okay, so this provision is given under section 159. So section 160 talks about the provision related to right of persons other than retiring director. So right of persons other than retiring directors to stand for directorship. Okay, so any other person who is not a retiring director can also stand, but there are provisions given under section 160 for it. Okay, so as a person who is not retiring is also eligible to stand, but as per the corresponding rules, okay, 13 of the appointment and qualification of directors, so there has to be requirement of the written notice. A person who is not a retiring director shall be eligible for appointment, but he has to give the written notice signifying his candidature as a director at least 14 days before the meeting. Instead of above person, some other person, okay, of the company who intends to propose may also propose a director. So there are two conditions: written notice, okay, before 14 days of meeting, then requirement of deposit, maximum rupees 1 lakh or higher. Okay, but this is not applicable for independent director appointment. Okay, so at least 7 days before the meeting, okay, company if receives any candidature, okay, will have to inform to the members about such proposal. And refund of deposit, there can be action by company, you can say, to inform members before 7 days of meeting. And then refund of deposit. Refund of deposit. Okay. A person gets more than 25% total valid votes. And there was one concept, that is appointment of the director elected by small shareholder. So even the director can be elected by the small shareholders, means the small shareholder holding share value of nominal value of not more than 20,000 rupees or such higher sum as may be prescribed. So appointment can be made with respect to the director by small shareholders. A listed company may, upon notice of not less than 1,000 small shareholders or 1/10 of total number of such shareholders, okay, whichever is lower, have a small shareholder director elected by the small shareholders. So they will represent or protect the interests of the small shareholders. So I think that's it from my end today. So you can just make a note of all these pointers, whatever we have completed from appointment of directors. We talk about first directors, subsequent directors, other requirement of appointment of directors. This is allotment of DIN, providing DIN and furnishing of declaration, written consent, rotation. Then we talk about DIN provisions. Directors will have to intimate DIN. Then there is obligation to indicate DIN. Punishment for the individual or director, and rights of persons other than retiring director to stand for directorship. The written notice has to be given, requirement of deposit, action by the company, and refund of deposit. So that's it from my end in this session. Okay, we will continue with the director's appointment session in the next lecture. I hope you understood all these provisions. We have studied from section number 149 to 160 along with the definitions of directors and board of directors. Please do watch this video. We'll again meet very soon in the next session and we'll continue that. Thank you so much for watching this video.